Hi guys, I hope you enjoyed our episode on the various contract clauses. Today we are jumping back into litigation, as I'll be explaining everything there is to know about claims for damages in South African law. After this episode, we will draft various particulars of claim in respect of which damages are claimed. What is a claim for damages? A claim for damages is a financial claim that is instituted to compensate a plaintiff as a result of a loss-causing event that occurred due to the fault of a defendant. In terms of our law, a plaintiff may not claim punitive damages from a defendant, as this is seen as being contrary to public policy. A plaintiff is only entitled to the damages that he can prove he suffered. In some circumstances, a plaintiff may claim constitutional damages, but we will touch on this shortly. Damages are claimed due to a loss of some sort by the plaintiff, which is caused by the defendant. The loss in question can either be financial in nature, which is pecuniary, or non-financial, which is non-pecuniary. Pecuniary loss is where the damages are quantifiable. Examples of pecuniary loss include hospital, medical, and related expenses, vehicle repair costs, and reinstatement costs. Non-pecuniary loss is not as easily quantifiable. The nature of non-pecuniary loss makes it difficult to assess or calculate damages in monetary terms. Examples of non-pecuniary loss includes pain and suffering and shock and trauma. A claim for damages may be instituted by a plaintiff in the event of a breach of contract, in the event that the defendant has committed a delict against the plaintiff, or where there has been a breach of a statute that provides for an award of damages or compensation in the event of such a breach. What types of damages can I claim? In South Africa, there are a few broad types of damages a litigant can claim depending on the circumstances of the matter and nature of the breach. These are contractual damages, delictual damages, statutory damages, and constitutional damages. Contractual damages. Contractual damages are those which stem from the breach of a contract. There are three broad categories of remedies available to a plaintiff in the event of breach of contract by a defendant. Remedies aimed at keeping the contract alive, remedies aimed at cancelling the contract, and remedies aimed at compensating the plaintiff for loss or harm caused by the breach. A claim for contractual damages is a remedy in the third category, serving a compensatory function. Take note, however, that damages for breach of contract may also be claimed without cancelling the contract. A claim for contractual damages may also be coupled with a claim for specific performance of the contract. To successfully claim contractual damages, a plaintiff must show that a contract exists or existed, the contract was breached by the defendant, the plaintiff suffered damage or loss as a result of the defendant's breach, a causal link exists between the breach and damages, and the loss was not too remote, depending on whether the damages are general or special. In terms of our law, a plaintiff is generally only entitled to claim contractual damages for damage that it can prove it suffered. When calculating damages, it is assumed that the defendant would have performed its obligations in the way least profitable to the plaintiff and most beneficial to the defendant. Take note that in some circumstances, the contract may contain a pre-agreed quantum of damages, which may be claimed, or a specific method for the calculation thereof. Think about the penalty clause we discussed in our previous episode. Should this be the case, the agreed method or amount must be used. The defendant may, however, rely on the Conventional Penalties Act should the penalty be out of proportion to the prejudice suffered by the plaintiff. Damages are usually, but not always, assessed at the date of the breach. There are three main categories of contractual damages, namely compensatory damages or positive interessa. These are actual damages suffered. Awarding compensatory damages is aimed at placing the plaintiff in the same position he would have been in had the contract been properly performed. An example of positive interessa would be a claim for loss of profit or loss of use and enjoyment of something. An easier example is to think of an immovable property auction. A purchaser buys a property for 1 million rand but breaches a sale agreement which is subsequently cancelled by the seller. The property is then again put to auction and sells for 500,000 rand. The initial purchaser who breached the agreement will be liable to the seller for the difference between the two purchase prices. Payment of the difference will put the seller in the position that he would have been in had the initial sale agreement not been breached. Restitutional damages, or negative interessa. Awarding this type of damages is aimed at placing the plaintiff in the position he would have been in had the contract never been concluded. Think about the following example. A and B enter into an agreement where A would purchase a car from B for 500,000 Rand. A made payment to B, however, after A made payment, B decided he wanted to keep the car instead. In this instance, A did not want to demand specific performance, but instead elected to cancel the agreement and claim damages in the amount of 500,000 Rand from B, so that A could be placed in the same position he would have been in had the contract never been entered into. Complementary damages. These are damages as a substitute for the missing part performance or as a complement of defective or incomplete performance. Here's a scenario for you. A and B enter into agreement where A would attend to various upgrades at B's residence for a fee. B paid the full price of A's services up front. A completed 75% of the upgrades and then suddenly absconded and never returned to complete the job. B had to hire a third party to complete the upgrades. B cancelled the agreement with A and claimed damages for the expenses incurred to complete the job. In this example, there was part performance by A, with damages being claimed to substitute the missing performance. Despite the above explanations, there is no real practical value in observing the distinction between positive and negative interessa, and that it's a distinction which tends to obscure rather than clarify. Damages that are too remote from the breach cannot be claimed. In this regard, a distinction is made between general or intrinsic and special or extrinsic damages. General damages are those damages that flow naturally and generally from the kind of breach of contract in question, and which the law presumes that the parties contemplated would result from such a breach. The plaintiff need only prove that the particular damage was of the kind that flows naturally and generally from the type of breach in question. Examples of general damages include loss of interest resulting from a failure to pay a sum of money, and damages that result from the use of a product for its normal purpose. Special damages are those damages that, although caused by the breach of contract, are ordinarily regarded in law as being too remote to be recoverable, unless, in the special circumstances attending the conclusion of the contract, the parties actually or presumptively contemplated that they would probably result from its breach. A defaulting party will only be liable for special damages if two things can be proven. Firstly, the plaintiff must prove that there are special circumstances which make it reasonable to presume that the contracting parties contemplated the damage as a probable result of the breach of contract. This is known as the contemplation requirement. Secondly, it must also be proved that the parties entered into the contract with these special circumstances in mind, or that the parties agreed, expressly or tacitly, that there would be liability for such damages. This is known as the convention requirements. Factors to consider when determining what a defendant could be expected to have known and foreseen when contracting: expertise and knowledge, the commercial context of the contract, the scope and purpose of the contract, and previous dealings between the contracting parties. Special damages can be limited even further in the agreement by capping the amount recoverable for special damages to not exceed a certain amount, and/or by excluding liability for special damages in terms of a limitation of liability or exemption clause. We have discussed these clauses already. A defendant could potentially admit that it breached the contract, but simultaneously dispute that the breach caused the damages claimed or the quantum of damages claimed. A defendant could also argue that a particular requirement for proving damages was not met. An example of special damages is economic losses, such as loss of profit. Delictual damages. The elements which must be present to successfully claim damages as a result of a delict are: the defendant must have committed an act or actionable omission that is wrongful, that caused harm in the form of damage or loss to the plaintiff because of the fault, whether intentionally or negligently, of the defendant. Considering the above elements, a delict can be defined as an act or omission that is wrongful and that caused harm to the plaintiff due to the fault of the defendant. Delictual damages, or loss, can fall into three categories: patrimonial loss, injuries to personality or inuria, pain and suffering or psychiatric injury. Examples of patrimonial loss include damages to one's vehicle after a vehicle collision, medical, hospital and related expenses, and loss of income. Examples of inuria include emotional shock, wrongful arrest and detention, and defamation. Examples of pain and suffering and psychiatric injury include shock, and psychological trauma, actual pain, and loss of amenities of life. Each category of delictual damages can be recovered using specific remedies. These remedies are, in respect of patrimonial loss, the Actio legis aquilae, or the Aquilian action; in respect of injuries to personality or inuria, Actio in Uriarum; in respect of pain and suffering and psychiatric injury, it's the action for pain and suffering. The Actio legis aquilae. There are 5 essential elements for liability in terms of the Actio legis aquilae, namely, the harm must take the form of patrimonial loss, the conduct must take the form of a positive act, omission, or statement, the conduct must be wrongful, in other words, objectively unreasonable and without lawful justification, the defendant must be at fault, and his blameworthiness must take the form of either dolus, which is intention, or culpa, which is negligence, and there must be factual and legal causation. Factual causation, the conduct must have been a sine qua non of the loss, and legal causation, the link must not be too tenuous. The Actio in Uriarum. For liability under the Actio in Uriarum, the general elements of delict must be present, but specific rules have been developed for each element. For example, causation is rarely an issue and is assumed to be present. The elements of liability under the Actio in Uriarum are as follows: harm in the form of a violation of the plaintiff's personality interest, his corpus dignitas and fama, wrongful conduct, and intention. Action for pain and suffering. To establish liability for pain and suffering, the following elements must be present: harm or loss, in other words, the pain and suffering is intangible harm associated with personal bodily injury to the plaintiff; conduct in the form of a positive act, omission, or statement; wrongfulness or unlawfulness, in other words, objectively unreasonable and without lawful justification; fault, which blameworthiness must take the form of dolus or culpa; and causation, factual or legal. Where there are several defendants and it's not possible to ascertain the true extent of damage caused by each defendant, after leading all available evidence, the court may find that each defendant is liable to pay a proportion of the loss suffered. It often happens that the defendant's liability is determined before arguing quantum. You do not want to waste time focusing on quantum if there is a chance that the defendant might not even be liable. Depending on the circumstances of the matter, expert evidence may be required. Delictual damages are usually assessed on the date of the commission of the delict. Actuarial calculations provide a guideline only, and the court is not bound by said calculations. A plaintiff claiming delictual damages must proceed with all claims arising from the same cause of action at the same time. This is known as the once and for all rule. When estimating prospective loss, it is not necessary for a plaintiff to prove that there is at least a 50% chance that he will sustain damage in the future. If the plaintiff can show that there is some chance that damage may be suffered, a court may award damages that will cater for the possibility that the plaintiff might suffer future damages. For example, where liability has been established and the plaintiff proves on a balance of probabilities that there is a 30% chance that he may suffer damages in the amount of 100,000 Rand in future, the court will usually award damages based on the following calculation: 30% times 100,000 Rand equals 30,000 Rand. In addition to the above, when awarding damages for future loss, courts usually make provision for contingencies. Contingencies can be described as hazards that normally beset the lives and circumstances of ordinary people. Contingencies must be taken into account when calculating the future loss that will possibly be suffered by the plaintiff. Contingencies include any other possible relevant future event that might otherwise have caused the damage or a part thereof, or may otherwise influence the extent of the plaintiff's damage. Contingencies usually reduce, but sometimes increase, the amount of damages to be awarded to a plaintiff. Before we conclude with delictual damages, take note of Uniform Rule 18, subsection 10 and subsection 11. These subsections concern pleading requirements where the claim is for damages. Uniform Rule 18, subsection 10. A plaintiff suing for damages shall set them out in such manner as will enable the defendant reasonably to assess the quantum thereof, provided that a plaintiff suing for damages for personal injury shall specify his date of birth, the nature and extent of the injuries, and the nature, effects, and duration of the disability alleged to give rise to such damages, and shall as far as practicably state separately what amount, if any, is claimed for, medical costs and hospital and other similar expenses, and how these costs and expenses are made up, pain and suffering, stating whether temporary or permanent and which injuries caused it, disability in respect of the earning of income, stating the earnings lost to date and how the amount is made up and the estimated future loss and the nature of the work the plaintiff will in future be able to do, the enjoyment of amenities of life, giving particulars and stating whether the disability concerned is temporary or permanent, and disfigurement with the full description thereof and stating whether it is temporary or permanent. Uniform Rule 18 subsection 11 states that a plaintiff suing for damages resulting from the death of another shall state the date of birth of the deceased as well as that of any person claiming damages as a result of the death. Clear from what I've just mentioned is that a plaintiff is required to set out the claim in such a manner as to enable a defendant to estimate the quantum of damages. Statutory damages. Some legislation prescribes that a plaintiff may be awarded damages under certain circumstances. Examples of such legislation include the following. Section 49D subsection 1, read together with Section 65 subsection 6 of the Competition Act. This section entitles the Competition Tribunal to hand down a consent order that may contain an award for damages because of loss suffered as a result of a breach of the Act. Section 61 of the Consumer Protection Act states that a producer, importer, distributor, or retailer of goods, as defined in the Act, is liable for any harm caused by unsafe or defective goods, also as defined by the Act. Constitutional damages may also be awarded in certain circumstances, which we will discuss next. Constitutional damages. In terms of Section 38 of the Constitution, a court may award damages for a violation of rights in the Bill of Rights. This section specifically refers to the granting of appropriate relief. Determining whether to award constitutional damages, as well as the quantum thereof, will depend on the circumstances of each case, the particular infringed right, and the other remedies available. Constitutional damages are not appropriate relief where a plaintiff could be compensated by intellectual damages, and where that in itself is a powerful vindication of the constitutional rights in question. In most, not all, cases, the common law will be broad enough to provide all the relief that would be appropriate for a breach of constitutional rights. Accordingly, where the violation of a constitutional right involves the commission of a delict, an award of constitutional damages in addition to those available under the common law will seldom be available. If a common law remedy exists, a plaintiff must first have recourse to that remedy. This is not always the case. Consider the matter between the families of mental health care users affected by the Gauteng Mental Marathon Project versus National Minister of Health and others, which is the Life Esidimeni tragedy. In this matter, the arbitrator found that the concerned state organs and indeed non-governmental organizations were obliged to respect, promote, and protect constitutional entitlements of mental health care users. These include the inherent human dignity, right to life, freedom and security of the person, especially the right not to be tortured in any way, and not to be treated or punished in a cruel, inhumane, or degrading way. But what stands out is the breadth and depth and frequency of the arrogant and deeply disgraceful disregard of constitutional obligations, other law, mental health care norms, and ethics by an organ of state, its leaders, and employees. In short, besides the reasons for the termination being untruthful, the decision to terminate the contract was irrational and in blatant breach of the law and the Constitution. The irrational and thus unconstitutional decision was the reason for the death and torture that ensued. This wanton, arbitrary, and unaccounted decision has caused so much pain and suffering, stress, trauma, and morbidity, and in my view is a very serious breach of the constitutional obligations by the state and its servants. Such a breach, together with other considerations, will weigh heavily on the character of the just and equitable redress. The government failed them dismally. In fact, the government proactively invaded their multi-constitutional guarantees, despite warnings and protests from organized clinicians, psychiatrists, psychologists, and formation of families. In effect, the government has invited me to squeeze this pervasive and reeking violation of our Constitution and many valuable laws into psychological injury and shock for which 180,000 rand might be the going rate in trial courts under the common law. I decline that invitation. this is a matter of massive proportion for the utterly defenseless mental health care users who deserve every care in the world and every protection and vindication a tribunal like this can afford them. The government is ordered, inter alia, to pay R1 million to each of the claimants listed in Annexes A, B, and C as appropriate relief and compensation for the government's unjustifiable and reckless breaches of Section 1, subsection A, C, and D, Section 7, Section 10, Section 12, subsection 1D and E, Section 27, subsection 1A and B, and Section 195, subsection 1A, B, D, E, F, and G, and multiple contraventions of the National Healthcare Act 61 of 2003 and the Mental Healthcare Act 17 of 2002 that caused the death of 144 mental healthcare users and the pain, suffering, and torture of 1,418 mental healthcare users who survived and their families. Limitations on damages claims. A defendant who has been sued for damages due to his negligence may raise the defense of contributory negligence. Where a plaintiff suffers damages and the damages were caused partly due to the plaintiff's own fault and partly due to the fault of a third party, contributory negligence arises. The Apportionment of Damages Act regulates this. Where there is more than one defendant, the defendants may be held jointly liable with one another towards the plaintiff. Naturally, each defendant's damages quantum will be reduced. Take note that the Apportionment of Damages Act does not apply to an action based on breach of contract except in the case of auditors. As mentioned under contractual damages, a defendant's liability may be reduced due to the existence of a clause capping the maximum amount of damages payable. In the case of a penalty clause, the defendant's liability may be reduced should it successfully rely on the Conventional Penalties Act. And that concludes today's episode. I hope you guys enjoyed.